minutes for it to show up on my end here on Facebook. Looks like it's live on Facebook, and let's just give it about a minute or so for it to alert people that we're actually on, so we can start having people come on. Looks like Counselor DeMont's already on here. I love how excited he is for this broadcast. Anyone else that hops on, just go ahead and gives us the thumbs up that you can hear me just fine. Hello, Peter. Good morning to you. All right, Michael, we're going to go ahead and get started. Good morning, everyone. Thank you so much for tuning into our broadcast. Today is Wednesday, and I know this because I just double-checked the calendar. And we had an awesome socially distant after hours yesterday. Just a quick shout out and thank you to 5280 Burger Bar and Linda Delano from Country Financial, both our hosts and our sponsors. And Mike, I know you couldn't come out, but it was awesome. We had cars that were basically parallel to each other. They'd roll down their windows, chat for a little bit, then the horn would honk, and then they'd move forward. We had 6 feet of socially distancing going on. People had their masks with them, and we had gloves and everything. It was an awesome time. So last night. We're back at it today with our webinars. For those of you that are just now finding our page out, welcome. Please be sure that you keep coming back. Like our page and follow us so you can continue to get updates and reminders as we go live. And find us on all of our other social media platforms. So if you're not already a friend with us on our Instagram and our Twitter pages, we're at West D Chamber. You can find us there where we share other information resources at all times, but especially during COVID-19. All of our previous videos are available to you here on our Facebook page. You can find it under the videos tab, and we've also pulled them onto our Facebook and our YouTube page as well, where you can find just a treasure trove of a lot of the videos that we released starting in March when this kind of situation started unfolding to help businesses adapt to the new environment. Now we offer more of videos that are geared toward our city elected officials. So our mayor is on here on Mondays with us, and we generally conclude on a Friday, with the exception of this week. We generally conclude Friday with our other electeds, whether it's school district all the way to the state level. And then now, since we're moving into this safer at home approach, we decided to change the wheels on what our video content is and how it can help our businesses. So we recently launched a reopening survey for our business community. A lot of you are getting phone calls from us to complete those. You can also take the time to fill that out on your own. It's on westminsterchamber.biz under the resources tab. You'll find a survey. We want to hear from you. What are your concerns as you're opening up? More importantly, how can we be supportive of you, and how can we help you as you're transitioning to this new phase? From the feedback that we're getting out of those surveys is really how we're driving these videos moving forward. So yesterday we had an awesome discussion about, getting your business to open, but still keeping your employees safe. So different testing options that are out there and things that you can implement for your business that basically follow the guidelines provided by our public health departments. Today, we have the pleasure of hearing again from our general counsel, Mike Lazar. And since Mike's video last time pulled a really good audience and engagement, I figured I'd bring him back. But Mike is our general counsel, and he works for a law firm down in Denver. He'll share with us the name of that and a little bit more about what they do. But our topic today is really focused on the legal implications of reopening. And this has been derived from a lot of questions that we're hearing, uncertainty from business owners, not sure on, who would be the deciding factor on certain cases or situations that they might face. So kudos to a lot of the people that are already on here with us. Hi, Cesar. It's good to see you. I miss all of my ambassadors. I feel like I haven't seen you guys in decades. State Representative Tracy Kraft-Tharp and Councilor Bowles. John Bodner, hello to you. Hopefully I'll see more of you as I finally get you on board with our organization, and Wayne Anderson. So we've got a lot of folks that are already on here. I'll keep doing shout outs. But if you have questions or comments, please type them into this video stream so we can pull them at the end and have Mike answer it. And with that, I've stopped talking and giving you updates from Chamberlains, and now let's hear it from the expert.
Thank you, Juliet. Again, my name is Mike Lazar. I'm an attorney with Feldman Nagel Contafio. We are a full-service firm that is based in downtown Denver. We also have offices in other parts of the state and presence across the country. So what a full service law firm means is that we provide legal services to everybody that encompasses pretty much most aspects in terms of what, sorry a second, I'm getting dinged in my email. So we provide pretty much most types of legal services that most people could want. So that would include full suite of civil litigation services. It would include divorce and domestic and family law. We provide criminal defense work as well. We handle pretty much everything. I would say the only two major exceptions would be the big specialized areas of one would be patent law, and then the other one would be securities law, which is kind of its own special beast. In terms of what I do, I am a commercial litigator. I do a lot of business litigation. I also have a background as a civil litigator doing a lot of plaintiff's personal injury work as well, and that's going to come in quite handy today as we talk about some of the liability issues that are attendant to reopening in this new era of COVID-19. And then I also serve as outside general counsel for a number of businesses and various industries. So the chamber would be one. I've represented oil and gas companies, tech companies, assisted living facilities, restaurants, pretty much people in every type of business, and it's all fun. It's always great being able to work with people, work through their problems, and get to know how they earn their living. So, with that in mind, let's talk about liability issues, and here's the first thing that I want to focus on right now. What I'm going to be talking about today are going to be some of the finer points of law, just to kind of give you a bit of a framework and a background to work with and to help you think through some of the issues that are unique to your businesses. I would say that the one practical step that I would advise everybody to take, however, is you need to make one phone call, and that's not necessarily to me or any other attorney, but make a phone call first to your insurance broker. And the reason why you want to do that is you want to make sure that your business is insured for everything that you're doing. Now, I'll say that I'm pretty sure that all policies right now have exclusions for virus or sickness related liability. But what we find is that whenever these types of big type of sea change events happens, where everybody starts where it causes everybody to do business a little bit differently as a result of some new type of liability arising, insurance companies tend to change with the times too. So I would recommend to people that they call their insurance agents, figure out how their policies are changing, figuring out what types of coverages are available, and then what they need to be doing to help avail themselves fully of all the insurance benefits that they are purchasing, and also to make sure they have just the appropriate types of coverage for their business, for their needs, and for the types of exposure that they have. And then, of course, if y'all ever have trouble with your insurance companies, give me a call, because I love going after insurance companies. And I've done a number of bad faith claims for insureds against their insurance companies when they fail to live up to their expectations. So let's talk about the actual legal framework that we're going to be dealing with. When we're talking about liability, we're talking about two different sources of legal authority that creates liability for people when others get hurt or injured. The first is going to be the common law. And so the common law is the history of judicial decision making that's been made, stretching all the way back to Old England in the very old days before the founding of the United States. And then the other source of liability would be what's called statutory authority or regulatory authority, where governmental entities create liabilities for business owners or for just people in general. So I think in this case, it's important that y'all be aware of both, because your liability can arise in both circumstances depending upon what it is you're doing and who the person is that may or may not be injured, depending upon what you did. Okay. So when we're talking about the common law and we're talking about the types of claims that are available under the common law, I would say that there are two big ones that you need to be aware of right now. The first is going to be assault/battery claims. Those will be intentional tort claims. And then the other one is going to be negligence claims. So assault and battery, I guess, in the era of COVID-19 would look something like, Juliet, she invites a business member into her office, and then she, intentionally coughs on him at that point. That would be very bad. That would be a battery, and that could be something that she's liable for potentially. But I'm just going to go out on a limb here and presume that most Westminster business community members are not going to do something like that. So I'm not going to spend that much time talking about what liability looks like in that case, because it's kind of self-evident. If you do something bad, like if you hit somebody, strike them, spit on them, do anything like that, you're going to get in trouble for it, and probably rightfully so. So really what we're talking about under the common law in terms of the main thing that business owners need to be aware of is this idea of negligence. And so what is a negligence claim? A negligence claim basically means that you as an individual have failed to exercise reasonable care to the extent that you owe a duty to a third person to protect them from some kind of injury. Okay, and I'm going to talk about the reasonable care concept a little bit later, because that's really where the rubber hits the road. But I at least want y'all to kind of understand the legal framework first. And so, aside from reasonable care, the other key concept there is do you owe a duty to this person? Well, Colorado law generally draws a dichotomy between two types of negligence cases. There are cases of what's called misfeasance and then cases of nonfeasance. What misfeasance means is that you, as the civil tort liability defendant, did something bad that negligently caused someone to get hurt. Nonfeasance means that you didn't do anything in and of yourself, but the person got hurt anyway as a result of something for which you may have had a responsibility to act or to save that person. The reason why this dichotomy is important under Colorado law is because, generally speaking, there is no duty to act in nonfeasance cases or in nonfeasance situations. There are only a few exceptions to that. And that's where there are special relationships between you as the defendant individual and then the plaintiff person who got hurt. And so these types of special relationships would be like the innkeeper guest, hospital patient, employer employee. What else? There's carrier and passenger, so like taxi services and things like that. For landowners and invited guests. And then the parent-child relationship would be the last one. So in those circumstances, the law says, all right, because of the circumstances, you have a responsibility to actually take actions to help protect people from bad things that might happen. So any questions about kind of that idea in terms of when you're responsible for misfeasance versus nonfeasance, in terms of having a responsibility to take some kind of action to protect people? Does that make sense, Juliet?
That makes sense. We don't have questions specific to that, okay. So we'll just kind of plow through and then get to the other ones here in a little bit.
All right. So what I would say is that to the extent that we're dealing with negligence cases, I would say that the big takeaway is this, is that if you're a business owner, you're going to be inviting people onto your property. And so you are going to have a responsibility to your guests, to your customers, to take certain actions to protect them. You'll have the responsibility to exercise reasonable care in those circumstances. And it'll be the same deal with your employees too. So if you're an employer and you have employees coming into your office, you're going to have a responsibility to exercise reasonable care to protect them as well. Now, the employee circumstance is a little bit different. And the reason why I say that is because the common law responsibility of the employer to protect the employee has been supplanted by workers' compensation laws. So it's a whole statutory framework there, such that if an employee gets hurt on the job and in the course of performing his or her duties, then you have a workers' comp claim. You don't have to worry about civil litigation. Just everything goes straight to some kind of administrative resolution. And the trade-off there, just so you understand, is that you as the employer are protected from certain types of damages that the employee might otherwise bring against you for getting hurt on the job. But in exchange, the employee doesn't have to prove any kind of fault on your part, if that makes sense. Okay, so let's talk about the more important thing, and the reason why I think most of you are here and what you're most curious about. What about my customers?
I have a question that's shown up, Mike, that I want to just pull up before we pass this section real fast, and it looks like it's from Counselor Seymour, and he's asking, is there an assumption of risk, especially a known risk? Is there not?
It depends upon the type of law that we're dealing with. So if we're dealing with negligence cases, yes, assumption of risk can be a defense. The other thing that I would state is that comparative negligence, so the idea that the plaintiff did something wrong to contribute to their injury, is always a defense, both in negligence cases and in what I'm be talking about next, and that's premises liability cases, which is the main statute I think that y'all need to be aware of as business owners. So what's the premises liability statute? Well, you may have heard me talking about negligence cases, and then one of the special relationships for which individuals owe a duty to people would be in the landowner and then invited guest category. Well, Colorado, like many states, has created a statutory framework that handles those types of claims in that type of situation. And that's called the Colorado Premises Liability Act. And the Colorado Premises Liability Act applies and governs liability whenever a landowner is sued by a plaintiff arising from claims related to the landowner or relating to the plaintiff being injured as a result of an activity or condition occurring on the landowner's property over which the landowner had control. So that's kind of a mouthful there, and I want to break it down a little bit just so you guys understand. So the most important concept is this idea of what is a landowner under the statute. Simply put, a landowner is someone who is either a person in possession of the property where the person got injured, or it's someone who is otherwise legally responsible for the property or the condition of the property where the person got injured. So for you business owners, all of you who are leasing space where you have your offices or where you're inviting your clients, you are all landowners under the premises liability statute because you're actually possessing the property. Being a landowner under the statute has nothing to do with actually having title or owning the property itself. All it means is that you're there and you're occupying it. And then the other thing that I would say is that for people who are, let's say, those of y'all in the construction industry, for example, or tradespeople, if you're entering the property that some other business, for example, let's say that you're a plumber and you go to a restaurant and you're trying to fix the plumbing there. You leave all sorts of tools lying around. You make a big mess wherever you are, and then someone slips and falls on the property there. Well, that's still going to be a premises liability claim because you're going to fall under the second prong of the premise of the landowner definition, and that is you're a person who is legally responsible for the condition on the property that created the injury. You were invited onto the property by the business owner to go do the repairs, so you're allowed to be there, and then you're the one who's actually conducting the repairs and making the big mess. And so if someone gets hurt as a result of something bad that you did, then you also are going to be considered a landowner on the premises liability statute, and you can be held liable under that. So the big takeaway here that you need to understand about when the premises liability statute applies is that it almost always applies as a kind of a general rule. And it's the first place I always look as an attorney whenever someone comes to me telling me about a claim, is that if someone's injured as a result of some condition on property, it may be a premises liability claim, and probably is in most circumstances. Okay, so that's kind of when it applies. So how does it apply? That's the next question. Well, what the premises liability statute does is it creates 3 standards for liability of the landowner depending upon the status of the plaintiff. And there are 3 different statuses. There are invitees, there are licensees, and there are trespassers. Invitees are people whom the landowner invites onto his property. These are typically people who are there for business purposes for the benefit of the landowner. So if you're a business owner, every single one of your customers and clients is going to be an invitee, and that's a very important concept to understand. In those circumstances, you are responsible for exercising reasonable care with respects to dangers about which you either knew or should have known. And so what that means is that you're responsible for protecting your customers from dangers, not only those about which you actually have knowledge of. Let's say, you know that there's like a patch of ice that always forms outside the door to your business. Like if you know that's there, yeah, you have an obligation to go out there and go clear that up for your customers so they don't slip and fall and injure themselves. But beyond that, you're also going to be responsible for things that you should have known about but may not have actually known about. So these could be things like I'm trying to think of a good example here. Let's say that you're supposed to I don't know, do routine maintenance on your premises. You're supposed to have carbon monoxide detectors in there, things like that, and there are other obligations that you've undertaken under the lease to protect people, to make sure that there are no dangerous conditions on the property. If you're not like doing due diligence to actively look for some of those potentially dangerous conditions and go fix and go correct them, then you can be held responsible if someone gets injured because you didn't, take the time to go look around and see what was going on the property. Okay. So that's the most important standard for business owners to be aware of, is that invitee standard. When you're talking about licensees, these are just people who are allowed to be on the property but aren't necessarily invited there for business purposes. Think like instead of a customer, you have a social guest there on the property. Those people are going to be licensees, and in those instances, you as the landowner or as the business owner are going to be responsible for protecting them against dangers about which you actually know about, so you don't have to worry about that should have known or that constructive knowledge issue. And then with trespassers, those are people who aren't supposed to be on the property at all, and they barge right on in. You're only liable to them if you willfully or deliberately injure them. So I, think back to law school, and there's a famous case where someone put in like a shotgun trap at an abandoned property of theirs to keep intruders away. Well, someone barged in who was an intruder, got shot, and they were found to be liable for that. So, that's the kind of situation where, you can be liable to even to a trespasser. So don't put any like booby traps or death traps into your businesses, please. It won't end well.
We've got a couple of questions that I think tie really well into the subjects that you just addressed. One comes from our present board member, Wayne Anderson, and he's asking, what if the customer gets injured in the common area? Can the liability extend to the business or just the building owner?
Yeah, that's a great question. The answer is that it depends upon what the lease says in those circumstances. So remember, the Premises Liability Act is going to apply to people who are either persons in possession of the property or persons who are legally responsible for the condition on the property that causes the injury. So when you look at your lease documents, typically you as business owners, what you're leasing is a defined set of space on a larger property. So if you have an office, let's say you're renting out an office at a business park, for example. Well, what you're typically going to be renting will be the actual rooms where your business is at, and then beyond that, your lease is going to define other areas to which you may have access or your clients have access and permission to access. And then beyond that, it will define what your responsibilities are with regards to maintenance obligations or other obligations as they pertain to taking care of the common areas at the property. Most leases are going to say something like, you, the tenant, are responsible for everything that goes on within the actual lease premise, as described in Exhibit A, which typically describes your lease property in detail, what you're actually taking possession of. And then there will be provisions in there that talk about the common areas otherwise. Most of the provisions that I see may require some degree of maintenance from the tenant, or they may not. Beyond that, typically landlords will keep language within their agreements that state something along the lines of, tenant's not allowed to make any changes to these areas without the express written permission of the landlord. If you see a clause like that, it could be that you, the tenant, and the landlord are potentially liable for it. Really, it kind of depends upon what the lease document says and how the duties are allocated between landlord and tenant.
Excellent. Okay, yeah, if we can keep plowing through, I just kind of quickly scanned, Mike, and these questions a little bit broader. So I want to have you hit some of those other points that we have, and then we'll come back to them.
All right, so let's talk about the most important thing that I'm going to talk about today, and that is, what is this reasonable care business under negligence claims and the Premises Liability Act? Because really your liability is determined by what is reasonable care. I mean, when is it reasonable to go out and go clear the sidewalks of ice or clear the property of ice? When is it reasonable to post warning signs as it may pertain to certain dangers that are on the property? And here's the answer to that, and you're not going to like it, but the answer is this: reasonable care is what the jury decides when it's all said and done. And what I mean by that is, we as litigators hire experts all the time to get out there and go talk about industry standards as to what reasonable care is, what people should be doing or should not be doing, as the case may be. But at the end of the day, it's up to the jury in court to actually determine what is reasonable care. And so when we're talking about what a jury is and who juries are, we talk about a jury of our peers. But I want to make sure that people understand what a jury of your peers actually means. As Brian Head, our former chairman, points out, a jury of your peers means a jury of 6 random people from the DMV, and I think that's very accurate, because you're going to get people from all walks of life sitting on juries, and you don't know who they are, you don't know what their backgrounds are going to be. They're not really going to be your peers. They're just going to be average citizens out there who have their own thoughts, their own biases, their own predilections in terms of how they see these things and what they think is reasonable at the end of the day. So let's talk about how that applies to COVID-19. One of the hot issues right now is this issue of, all right, do we all need to be wearing masks? Is that reasonable? Is that necessary? Well, there are a lot of people who say, no, that's not necessary at all. In fact, it's quite unreasonable. It is even ridiculous to have to wear masks right now, especially these, cloth masks that don't necessarily stop the virus from, going in and out or going anywhere. But on the other hand, there's also a substantially large group of people that state that, well, they don't state it necessarily, or just state it, but they have the expectation that everybody wears masks now. That it is reasonable in this day and age to go out, have the mask on at all times, and make sure that you're not doing anything that is unreasonable to spread COVID-19 around. So, getting back to this idea of, who's deciding this? Well, it's that jury of 6 people that comes from across all walks of life. They may or may not decide that, yeah, you got to have a mask on, and it's negligent if you do not have masks on at your place of business to protect your customers from virus exposure. So does that make sense? I mean, that's a really difficult concept that I think a lot of people don't understand about our court system and how it works, is that really it's kind of up to the community to decide what reasonability is.
Absolutely. And I think you touched on a really good point. We had some sidebar conversations leading up to this really broadcast, Mike. And we actually had one of our viewers right now. We have Tina. We have a lot of people that have hopped on. Jenna Swanson, hello. Tina Francone and Vanessa DeMont. I'll try and get to everybody for a shout out. But Tina Silver is a small business owner. And I know she's been facing some resistance from people in the community that are telling her, you need to be doing this type of stuff for hygiene purposes. Why aren't you opening your doors? There's a lot that's embedded in this question that she's asking. And so she shared, that if she wants to institute where you have to wear masks, which if we look back on council, there's been a recommendation recently this past Monday that encourages this at places of businesses, more than encourages really. But her reference is there was some resistance on the council to that. Has scared her as a business owner, makes it hard for her to open, not knowing that there could be a liability. And so this goes back to our initial conversation, Mike, about how much liability would there be on a business if they choose to implement whatever they would like to, and the concept of, does a business need to have a mandate to be able to do things, or can they do that on their own without having that repercussions from there?
Okay. This is a very important question because it, takes me out of this academic legal realm where we're talking about the possibilities, and it forces me to consider the more practical. And here's how I think about this. And again, this is just my opinion. The thing that I want to stress here is that these are all new and novel issues. None of this has been litigated yet. It hasn't been decided, has not been looked at by courts. But let me present the opinion of someone who has done a lot of plaintiff's personal injury work, and why I would not like this kind of claim if I was representing someone who wanted to make the argument that they were infected by COVID-19 from XYZ business owner or at XYZ business. The main problem that I have with this claim is that whenever you as a plaintiff bring a lawsuit and you're bringing claims against the defendant, the burden is on you ultimately to present evidence in support of your claims and to convince a jury. And even before you get to a jury, you have to muster enough evidence to show that there's actually a triable issue there. Mm-hmm. My concern with these types of claims from a plaintiff's perspective is, how do you prove that you got the virus from that business or from any one particular location? I mean, if you think about what's going on right now, all of these people, or not all these people, but everybody is not just locked at home all the time. They're going out, they're doing grocery shopping, they may be running other errands, other chores, potentially other, social gatherings and things like that they maybe should not be doing, but are doing anyway. If I'm a defense attorney, very first set of questions I'm asking the plaintiff during a deposition is, well, where else have you been? Where else may you have gotten an infection? Why are you so certain you got it from my client? Mm-hmm. And I just can't imagine what the good answer is going to be, unless, getting back to our earlier conversation, they say, well, I'm pretty sure I got it from the Westminster Chamber of Commerce because Juliet had a really nasty cough and sprayed me. I mean, that's not going to happen very often. At least I can't imagine it happening very often. So what that tells me is that this type of liability probably is more academic than something that's a real practical concern that businesses have to worry about. So if we get away from the issue of worrying too much about the liability for getting people infected or exposed to COVID-19, now we're focused with more of a business question. And that is, all things considered, what can I do to make my customers feel the most comfortable such that they, come and see me and want to spend money at my place of business? Mm-hmm. And that's a more complicated question. It's not really a legal question. It's really something you as business owners should be able to kind of gauge on your own, just thinking about, all right, well, these are my customers. These are their demographics. This is who I understand them to be. This is what I understand their sensibilities to be. And so taking all that into account, this is the kind of policy that I should have in place that governs, what my employees are going to be doing at our place of business and under what circumstances my customer should be allowed to enter my place of business.
Yeah, thank you. And then this question is from Counselor Bowles. When do you guess jury trials may begin again in our area?
All right, so the Colorado Supreme Court entered another order suspending jury calls into June. I forget the exact date right now off the top of my head. Like I discussed on the last one of these video presentations that I did, what's going to happen when they finally open up the courts again and they allow jury calls is that there's going to be a whole backlog of criminal cases that have to get sorted through first. So if you are a civil litigant, you're very unlikely to go to trial this year, especially if you have requested a jury trial. I just don't see it happening. And in all the cases that I'm litigating right now, I'm advising my clients, look, forget your trial date as is currently set. It's just not happening anytime soon. And, make plans with that in mind.
And I'm skipping back because there were some earlier comments. I'm trying to group them for you, Mike. This one was from Counselor Demont. Thanking us for the webinar. Again, goes back to the businesses. How do they keep themselves safe from issues with mask mandates for folks who have medical conditions that keep them from wearing them? What advice would you give? And he's referencing this, because of the recent passage on Monday, and where some people might have medical conditions that are not able to wear the masks.
Right. This is a really good question. It's fairly complicated in terms of how it works. So businesses are subject to various anti-discrimination statutes out there. I think here in Colorado, the one that you're going to need to be most worried about will be the Colorado Anti-Discrimination Statute, or Colorado Anti-Discrimination Act. And really what that act states is that you as a business owner shall not do anything that discriminates against people who are part of a protected class. And so the protected classes are going to be race, sex, religion, age, national origin, sexual orientation in this state, and then perhaps most importantly, per Counselor Demont's question, disability. So you want to make sure that you enact policies that are sensible and responsive to people that have respiratory issues. And the reason why is because it's well known that if you wear a mask of any kind over your face, you are necessarily restricting the flow of oxygen and air into your body. And for some people, they just can't handle that. Especially people who have to be on oxygen at various times. I mean, this is a real issue and a real concern. And so I would counsel people to be flexible and sensible with the policies that they enact as it pertains to wearing masks, because you really don't want to deal with the complaint being brought to the Colorado Civil Rights Commission or divisions, stating that, oh, well, such and such business is, discriminating against disabled people. You just don't want to deal with that hassle. So I would encourage people to be thoughtful and flexible with whatever policies that they create. Be always, as a general rule, if you're a business owner, and this has to do with employee handbooks, and many different facets of what it is that you do, try to give yourself an out and give yourself some inherent discretion to do the right thing. Try to empower and teach your employees to do the right thing and to not just rotely apply rules. You'll save yourself a lot of trouble if you do that.
It looks like our current chairman, Brian Dice, has been on here tuned with us. He had more of a thank you for, hopping on and doing a secondary webinar for us. It looks like this one's more related as a question. We can't keep it up the whole time or else it'll block you and I's spaces. So as a residential real estate broker, we have guidelines regarding the current COVID-19 issues that we're dealing with. For example, we need to have buyers and sellers sign new COVID disclosure docs before scheduling in-person showings. They're required to wear face coverings and gloves during showings. If a client or other broker's client refuses to comply, what is his liability for refusing service or access to those individuals?
I don't know why you would. Just kind of thinking this through, I don't know why you would owe a duty to these people. And we get back to the earlier conversation that I had. I mean, you as a real estate broker are obviously going to owe duties to your clients, but you're not going to be strictly liable for the bad behavior of other people. So if, for example, you're representing a seller and a prospective buyer does not want to, come to the property, and your sellers insist that the buyer wears a mask and wear gloves before they enter, it's really not your problem as the broker. It's really up to your client the seller to determine whether they're going to be flexible with it or not. I mean, no one's compelling your client to do business with this person. It's their choice at the end of the day, and for the most part, the law protects freedom of commerce and the freedom to do business with people that you choose to do business with or not do business with, as the case may be.
Excellent. And then it looks like we have, I don't want to skip over so I'm going to throw you a random question that's not in the mix with masks. Then we'll come back to the masks and disabilities questions, okay? So this is from Matt. Matt is with 303 Training Center, amazing partners that we have here in the community. They've got that, I know you've been over there, they've got that gold belt for the Brazilian Jiu-Jitsu Championship. I mean, it's just awesome. Martial arts school that's here, much like wrestling, there's a lot of contact while they're training. Any advice about adjustments that they would need to make on their safety waivers?
Yeah. I would say you probably should, especially if you're going to start inviting people to come back and train at the facility. I mean, when you're talking about waivers, they're generally fairly effective as long as you are getting informed consent from people to sign the waiver. So, what I would recommend would be to specifically address COVID-19 as an issue within the waiver. Say, look, we're living in this day and age where if you don't have it now, there's a very high likelihood that you are going to have it, and most people are going to get it at some point. If you're going to be tangling on the mats with other people, well, guess what? If that person has it, you may get it. So understand that that's an inherent risk in this activity and that you're waiving all liability that we may have for that.
Thank you. And a lot of good mornings. Good morning back to Kim Llewellyn and Denise King. Hello, Alberto, our former Mayor Pro Tem, for tuning in with us as well. And Dave Carpenter, it looks like you're commenting on a couple of different things over here. So Vanessa DeMont came back to the disability comment. So she's sharing, can a business owner ask what disability the customer has, or are those individuals protected by privacy laws? And a secondary to that, before you answer it, because we might be able to answer it one time, secondary to that is, so Tina comes back and she says, does that step into the HIPAA laws?
HIPAA is not going to apply in most of these circumstances because HIPAA is only going to apply to people who are handling protected health information specifically. And that's all defined within HIPAA itself. So the general rule is that HIPAA does not apply to the general public. It's going to apply to certain businesses and individuals in their handling of protected health data. And I don't have the statute pulled up here, but the statute will define who it applies to, and it's not the general public. With regards to what you can ask about the disability, yeah, you can ask about it. I'm not aware of any law that prohibits your asking. I don't think you can compel them necessarily from disclosing it. Now we're back to this issue of, all right, well, what are you going to do as the business owner if you have a mask policy and then someone claiming to have a disability wants to enter and you're not going to let them enter? Well, what I would counsel in those types of situations is, be lenient and probably err on the side of letting them in just to avoid problems. Because you as the business owner, what you don't want to do is you don't want to be inviting legal trouble. You're not in the business of lawsuits. You're not in the business of litigation. I am. That's my business. That's how I make money. That is not how any of you make money. So bear that in mind and, do what you can to be flexible to avoid getting sucked into some kind of legal mess like that would be my advice, practically speaking.
So, Mike, I know I've kept you over on time, and we have a really good, robust conversation. A lot of people that are tuned in with us, Ari, Lauren Seymour, and several others that have just kind of been hopping on. So I don't want to lose sight of the time. I know we were supposed to have you for 30 minutes. We have you for close to 45. What is a way, and a lot of this is more specific. Some of these questions that we're getting are really specific to specific industry. And so I want them to be able to, communicate back and forth to you a little bit more in detail and in scope of what they're trying to reference, a way that they can reach you directly by phone.
Sure. Give me a call directly on my office number, which is 303-813-1200. Again, that's 303-813-1200. I'm at extension 1027. I am going to the office now again, so you can reach me there. For all of y'all that are on Facebook, feel free to message me directly on Facebook as well. You can also email me. I'm pretty sure that my email address is on our website, which is www.colo-lawyers.com. So that's COLO-lawyers.com. I think that's an important point that you raised with regards to, how fact specific all of this is. What I'm trying to do here is give y'all a general framework of how to think about these types of issues. But when it comes to, the more specific cases and the finer points of how this applies to you and to your business, it all depends upon the facts. It always does. Depends upon what your business is, who your customers are, how easy it is for you as a business owner to adopt policies or make changes to your business to account for these risks and to facilitate these risks. For some of us, we're in businesses where it's really easy to kind of adopt on the fly. We can work from home all the time. We don't have to meet with customers. We can do phone calls or, teleconferencing, things like that, or video conferencing. But, for a lot of other businesses, it's much harder to be able to adopt to the threat of COVID-19 and all the complications that it is creating for us. So yeah, don't hesitate to call me, chat with another attorney. I'd be happy to kind of give you my thoughts and, share my experience in terms of what's likely to happen, as I see it anyway.
So I've included Mike's website in the comment section of this video broadcast. His phone number along with the extensions also written right there. Be sure to spam him, call him nonstop, and get your questions taken care of, and let me know how well he does in answering those for you. We do have Tina Francone thanking us so much, you, Mike, for the incredible, helpful, and timely information. Thank you, Tina. And the other Tina, thank you for tuning into the updates. And I so appreciate the kind words. So we've had a lot of people stream this video. If you end up watching this on replay, please give us a hashtag replay so we know you did. If you come up with questions later on and maybe you were tuned in right now but didn't have a chance to answer them, go ahead and ask it of us. We'll have Mike take a look at those questions, whether they'll email back to your response or comment them here onto our Facebook page as well. Be sure that you come and join us for the remaining broadcasts of this week. We'll have a different compilation that's put together next week. We already gleaned a little bit of insurance and things like that from this discussion, but know that tomorrow we actually have an industry town hall. So I won't see you at 11 a.m. I will see you at 4 p.m. I like those because it gives me my mornings back, but I'll be back with you with two associations, the Colorado Brewers Guild and the Colorado Hoteliers and Lodgers Association. So both of them have been impacted through COVID, especially the Travel Association. Hear from them on what they've been doing to combat it. And then we'll round out the week with an Atypical Friday session that's just focused on contactless payments, not our general elected officials, at 11 a.m. So again, we'll be back here at 4 p.m. tomorrow, 11 a.m. on Friday. If you need to reach out to Mike, his contact information is in the comment section. I thank you so much for tuning in with us. And Mike, I thank you for taking the time to just kind of run with it, hear some of the concerns from our business community and try and give them the peace of mind that they need, but also empower them to understand that the choices that they can implement in their business are entirely on them to do, and they can do that without feeling like they'll have some sort of a negative repercussion behind that. So again, thank you, Mike. Thank you, everybody, for tuning in.